And Philip Becnel is the managing partner of his own investigative group. And I don't know how you pronounce the first name in that group. Is it Dinolt?
Dinolt, yeah.
Dinolt, Becnel Wells Investigative Group. Author of two influential investigative books, one of which I just started reading, and I could tell right away as soon as I got into it, this is going to be straight to the top of my recommend list for investigators. The one I just started is Principles of Investigative Documentation, which a friend and colleague gave me as a gift. And then Philip also wrote Introduction to Conducting Private Investigations. He's taught undergrad courses in criminal procedure, white-collar crime, and criminal investigation, been interviewed as an expert for media stories on matters ranging from vetting clients to bribery and fraud investigations, testified as an expert witness. He's a member of a bunch of stuff I'm not going to read through because it'll take too long, but suffice it to say, some really good credentials. And Philip, I think we're all really excited to see what you have to offer today.
All right. Well, thanks for having me. I love giving these talks. So I realize everything I'm saying is coming up on the bottom of the screen. How cool. Yeah, thanks for having me. This is going to be pretty informal. I mean, there is a PowerPoint presentation, but mostly I'm just going to talk about the book and tell stories and pull a couple things from it that I think might be useful for people. I'm assuming that the folks who are in this meeting are like people who do investigations. I mean, as I said in the Principles of Investigative Documentation, it's not a book for people who don't already know how to do investigations. It's more, it's pretty technical, I guess. That's what I'm assuming that my audience is. But if you have questions about anything, just, you feel free to interrupt. It's totally fine. I'm going to talk about the book first, and then we'll get into some of the weeds. So this is the book I first wrote in 2012 with one of my former investigators. His name is Scott Krischke. He worked for me for, I don't know, maybe about 5 years. He had a journalist background. He eventually went to law school and got a law degree and is now working as a lawyer somewhere. And it started off as like a book about how we document cases at our own firm, but that sort of led us down a rabbit hole of best practices and how other people document stuff and how various legal issues affect how you document investigations. And so it turned into the book that I first wrote in 2012. And then the publisher bugged me to do a rewrite for basically the last decade. And I finally got around to doing it. And I brought on my wife, who just graduated from law school. But the time that we were writing this book, she was in the middle of law school. And so was like learning about all this stuff firsthand. And so she was really immersed in it. So it just made sense to have her help co-write it. It covers a lot of stuff. It covers various legal theories, some of which we're going to talk about today. Confidentiality, attorney-client privilege, hearsay, a lot of stuff, and how it affects the way that you document your cases, the rules of evidence, and other things like writing about race and gender in your reports, sort of practical advice for how to do that in this day and age. And then the sort of the bedrock of the book is what we call the 5 principles of investigative documentation. So that is basically a blueprint for how you document everything. And those five things are taking notes, keeping a running resume. I'll talk about what that is in a little bit. Writing reports, what your report should look like, of course. Statements, which is a broad term that encompasses a bunch of stuff, but how to take statements from people, when to take statements, what type of statement to use for different types of people who you're taking statements from. And then also document retention, how long you're supposed to keep your records for, and why we do that. So, and there's probably some other stuff in there that I'm forgetting, but it's kind of like an everything you need to know about documenting investigations told from the standpoint of somebody who's been doing this for a really long time. And I think it's pretty readable. I mean, I wrote it sort of, there's a lot of like tongue in cheek, stories and stuff about mistakes that we've made and other things. So that's the book. And that's kind of what we're going to go into today. Before we do that, how do I switch slides? Oh, nope. Sorry, I got to figure out how to actually, there you go. First off, disclaimer, I'm not an attorney. I don't pretend to be an attorney. I'm certainly not your attorney. I'm not giving you legal advice. I'm not giving anybody, listening to this legal advice. Some of the things we're going to talk about are legal concepts, which I happen to know, and some of the folks who wrote the book are lawyers. But what I'm going to talk about today is just general information. And so if you have a question about a particular case or about a particular case or a legal issue in a particular case, and I don't want to pretend like my advice applies to everybody everywhere. So I just want to make that super clear in the outset. Another thing I guess the book talks about that I guess I want to go into a little bit is just, and I'm going to tell this by way of a story, kind of a little rambling story. I recently went on an investigative trip to another city, and city's not important, but I rented a car, when I went to this other city, and I did an investigation there for a couple of days, stayed in an Airbnb. The car, I went to Dollar Rental Car, and my experience was, I get in the car, it smells like smoke a little bit, but that's okay. I don't really mind it so much. It takes me a really long time to get out of the lot. I go do the case, the car works fine. I don't have any problem with the car, as far as like the operation of the car. But when I turn the car in later on, I get a statement from them that says, like, that has some fee on it. It's like initially I don't notice all the fees, but there's a fee on it that's like, I don't know, like $15 for something that doesn't make any sense. So I'm like, well, that's weird, but it's only $15. I'm not making a big deal about it. A couple of days later, I'll call them and I'll sort it out. And then I realized that there's this other charge on there for like, the car smells like smoke, when I turned it back in. And so they're charging me this like cleaning fee. So ultimately I spend hours and hours, not hours and hours, but I spend a really long time emailing this company, trying to call them. You can't call them. And ultimately I'm like, I finally get an attorney to like sue Dollar Rental to get this charge taken away. And which is all really upsetting and also a big waste of my time. I mean, I have a lot of other things to do rather than like being on the phone with Dollar Rental. And ultimately, right before I meet with the attorney, they finally relent. I finally send an email and it finally goes to the right person and they take mercy on me. I'm like, car already smelled like smoke. I don't even smoke. So it's all one way of saying that, like, that's a pretty bad customer service experience, and it's really frustrating. And I think everybody's had that kind of experience from different companies that you encounter. And after that happened to me, it really made me think a lot about my own practice and how I perceive my, like, I guess, my role in the work that I do for the investigations that I do for my clients. And I was so angry about it. I wrote a nasty review. I did all the things that you can do, raising your fist and sort of being angry about it. But at the end of the day, I decided that it was like a teachable moment, that I was going to forever kind of look at that experience and other experiences like that to guide me in how I do and how I investigate for my clients. And I guess my take on that is that, no matter what kind of job you do, what we do is just a job. And it's like, it's a job, like working at a fast food restaurant, working at Dollar Rental, working at whatever, driving a truck, whatever it is that people do. They do stuff and they do it for money, and they might not like their job. And at the end of the day, maybe that's not what life's really about. It's about going home and spending with your family and blah, 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 and all that stuff. But I'm of the mind that if you're going to do something, you might as well do it right. And I'm also of the mind that no matter what kind of investigation you do, whether it's doing domestic cases or criminal defense cases or whatever, everybody who we work for, meaning the clients, not the attorneys, but the clients, they're going through a really shitty time, like, to be frank. There's nothing worth investigating that's not a horrible situation for the people that you're investigating it for. And so it's important, and I'm not going to say it's important in a way that, like, renting a car isn't important, because that's important too for the person renting a car. You know, you need the car, you need it to get around, you expect to be treated with respect, and you hope that they're not going to like overcharge you at the end. So that's an important thing too. But the investigations are slightly more important in that it has ramifications for people's lives. It costs people a lot of money, or cost them their freedom, and it costs them other things. And so, regardless of what the job is, I think you should do a really good job at it and try your best to be perfect at your job. You know, to do a good job for the people who you're working for. And so, the next thing I'll say, the next kind of thing that I believe about investigating, is that investigating, when you really boil it down, I mean, we do like a lot of things. We do, like, we interview people, we do surveillance, we do all the things that investigators do. But at the end of the day, actually, if you just distill what we do down to its essence, we're really in the business of selling investigative reports to attorneys or to clients, you know, and we document what we do. And that report, or that documentation, is the primary tangible work product of all the stuff that we do. So it's like, you know, my son, for example, my son is in college, but he works at a burrito restaurant. He rolls burritos for a living, and, you know, over the summer. And so his job involves rolling burritos, and he does a really good job at rolling burritos. And you want the burrito to be rolled and not to fall on somebody's lap when they take a bite. And so that, you know, the documentation that we do is ultimately that thing. And it's very important. And so I think because it's really important, you know, I guess what I'm saying is that I don't think that you should see it as something that's like, it's not something you do after the investigation. It's integral to the investigation. It actually is the investigation, which means that things like spelling and punctuation and all the things that go into making that report pristine are very important. And so the book talks a lot about those kinds of things, and sort of my philosophy on that. So I just wanted to give like kind of a little bit of a preview into that. So without further ado, let's talk about some of the things some of the stuff that's in here. I talked a little bit about the 5 principles. I don't have time during this to like go into all of them in a great detail, but some of them are kind of obvious. I mean, you know, taking notes seems pretty obvious, I think, to people who are doing investigations. But it's not all, you know, it's not just like the fact that you should take notes. It's the fact that you should, it's the fact that your notes you should take care in the way that you take notes, that you don't produce discoverable material to the other side. For example, if you're working a criminal case in some jurisdictions, it should be that you should do it religiously and with care, so that the notes enhance the information that you get that go into the reports. Running a resume is something that is the term tends to confuse people a lot, but a running resume is like it's kind of like a case, like a diary that investigators keep about all the things that they do in their investigation. So it's like usually use a case management system or something to do that, but they don't always call them running resumes. I've seen them like case updates or things like that. But we talk about how to keep a running resume, why it's important to share information through that system, and then the reports and stuff. I don't have time to go into all the different stuff that makes up a good report, but it's in the book. And then statements of document retention. I'm going to talk a little bit about document retention in a second. Does anybody have any questions about anything so far? I know I really haven't talked about much substantive except for my opinions, but I want to give everybody an opportunity to weigh in if they have a question.
I have one to ask. I'll just do this for a second to give people time to put stuff in chat if they want to. Are you thinking to talk a little bit more in this meeting about how to avoid producing discoverable material by the way that you do your report or your
I can if people
whatever?
ask about it. So yeah, I am actually. In fact, yeah, I will. Yes, I will. You don't even have to ask about it because it's the next slide.
Yeah,
so
I think that's a major
we'll just,
interest, actually. I know we talked about it beforehand. Like that's something we'd like to know more about, that and the work product versus client privilege.
Absolutely.
Situation.
So we'll just jump into that now. Okay. So yeah, there's a lot of like terminology gets bandied about among investigators. So the bigger one, confidentiality, attorney-client privilege, and work product. We'll talk about the three differences there. So first, I'm going to tell you a story. So, and this is in the book too, but I had this client once who hired us for a custody case, a child custody case, where we were doing, kind of run-of-the-mill case where he was just wanted surveillance of his I guess of his ex-wife at that time, when she was ferrying the kids around in different places, kind of standard stuff. Not what we do very often, but in any case, he reached out to us. And whenever somebody reaches out to me and they're not an attorney, like 99% of our clients are attorneys, really. I always give people the caution that the things that you communicate with them, there is a likelihood, and I would say even a high likelihood, that those things could be, I mean, discoverable is not exactly the right term, but they might be revealed to the other side in some fashion. And that's true pretty much whenever you're not working for a lawyer. And I'll tell you why that is in a second. But I make it a practice to always give people that warning, because I've had experiences of and the one I'm just about to describe, in which that's happened. So as an investigator, I don't know what the Idaho law is. Some states have statutes that require confidentiality in private investigations. Virginia's a place like that. I don't know if Idaho is or not. It doesn't really matter though, because I would say that there's like a prevailing standard of care among private investigators that we keep the information we gather as part of our investigations and our contact with our clients confidential. So it's pretty standard. You're not gonna go and publish the information that somebody tells you, because you're a private investigator and it's understood that that's not the way it's supposed to happen. So if you violate that, you could get in trouble in some fashion. But confidentiality is something that protects the client. So it doesn't protect the information from being revealed if there's something that triggers it to have to be revealed, like a subpoena. It is something that protects the client, and also it's a rule of conduct for you and for, I mean, attorneys have a rule of conduct for confidentiality too, whereby they can't reveal the content of their work to other people. There are some exceptions, like by the ABA guidelines, and if you're talking about confidentiality rules for like PI statutes, there are usually some exceptions there too. I think in Virginia, like if it's like threat to life or limb or something like that, things like that, there might be some reason why you could breach the confidentiality, but in general, it's presumed. And so that exists pretty much anytime, but it's a stronger and better established rule if you're working for a lawyer, because they have the ABA guidelines. Again, that protects the client. So it just prevents you from divulging that information. That's all confidentiality is. The other rules are a little different, but sort of related. So attorney-client privilege, it's not a rule of conduct, it's a rule of evidence. So it prohibits the sharing of information that's communications between the attorney and their client, and also agents of the attorney and their client, from being divulged to the other side, or being divulged to anybody, but particularly to being divulged to the other side. And so that doesn't only just protect the client, that also protects the information, and to some extent protects you. Attorney-client privilege doesn't exist unless there's an attorney involved. So if you take a private client, there's no attorney involved, you have a responsibility to keep that information confidential. But if you're subpoenaed, or usually the subpoena is the one that's going to make, then you might be required to divulge the information. If it's attorney-client privilege communication, which is when there's a lawyer and it's communication between the attorney and their client, or between you and their client, if you're on the legal team, then that protects that information from being divulged. But it's limited to just the communication between the client and the attorney, or the client and the attorney's agent, if that makes sense. So it doesn't include your reports generally. Like if you go out and you interview somebody, that's not attorney-client privilege information. That might be work product maybe, but it's definitely not attorney-client privilege information because the client's is not a party in that communication. So to step back a little bit, one of the things that triggers these protections is by being aware of them and also exercising them. So when you're writing reports, writing on the top of the report, for example, confidential, if it's confidential information, if it is in fact confidential, or if it is in fact an attorney-client privilege communication. In other words, you're working on a criminal defense case, you go to the jail or wherever, and you interview the defendant, who's your client's client, the attorney's client, and you gather information from them and you write a report about that. That's attorney-client privilege information. You should write that on the report so that it's clear that that's what that is. And the last one is work product, and work product is it's information that attorneys gather in anticipation of litigation, and that includes information that they gather as part of an investigation through their agents. So, work product is where most of your work is going to be attorney work product, not attorney-client privilege information, but attorney work product. And for attorney work product, it's not necessarily not going to be divulged to their side. The answer is it depends on what exactly it is. There's a chance that it might, but how you protect against it, it depends on what type of case it is and what jurisdiction is. I mean, I like to talk about, we do a fair amount of criminal defense work, and particularly federal cases are in DC, which follows the federal rules of evidence. And in those cases, in criminal cases in those jurisdictions, there are rules that there are rules whereby the prosecutor could obtain your notes and reports from witnesses who the attorney who you're working for calls as defense witnesses. And so ways to protect against that, this is kind of like getting into the weeds, but include not taking contemporaneous notes when you're talking to like friendly witnesses, not taking verbatim statements from them, not generating information that's likely to fall in that category. And so that's one way to do it. The other way to protect your information is by always working for an attorney, labeling the information that you labeling your reports what they are, and and practicing that. Obviously, if it's attorney-client privilege information and you copy the client's wife or somebody else who's not party to the communication, then you're violating the attorney-client privilege. I mean, that breaches it right there. So that person does something with it. There's nothing you can do about it. And so safeguarding the information, keeping it on the legal team, labeling it properly, and when you're taking interviewing witnesses in reciprocal discovery situations like in federal court, being careful not to generate what they call jinx or reverse jinx, which might be turned over to the other side. And I think that kind of answers your question. Is there other questions about that?
Definitely sounds like there's a lot more there to dig into. I think that covers it nicely for an intro. I think what I heard was you want to make sure to label it for what it is, because that can actually help to trigger the appropriate rule to apply. Is that what you're saying? Though it doesn't ensure anything, because depending on the rules of what's going on.
Right. I mean, like I said, it depends on the jurisdiction. Most of the time, I guess it depends on what could the other side subpoena your records, from the attorney in discovery, and your reports. Like, you go out and you do an investigation, you've interviewed a bunch of people, you've written reports about those interviews, and let's say it's a civil case, and the other side's like, give me all the investigators' reports about everything they've done. And I would say that typically that's not going to happen because like the work that you've done is work product, and there's rules of procedure about how that stuff comes in. Where your records are more likely to come in is if one of the people that you interview testifies, or if you testify about something that you did. And so that's when that's when that's when the records might come in under for various reasons. Um, but for example, I mean, if you let's say you interview a witness, and the case goes to trial many months later, and that witness on the stand is asked about the thing that you interviewed them about, and they say, I don't remember. So, and we're going to talk about this in a second, but that I don't remember might trigger one of the hearsay exceptions, which allows the attorney who's questioned them to say, well, isn't it true that you told Mr. Philip Becnel on March 3rd, 2023, X, Y, and Z? And that report might be used to then refresh their memory because that's one of the hearsay exceptions. And in that case, your report they might have to turn it over to the adverse attorney, because it was used to refresh the witness's memory, and then the report comes in, right? So the report, which was otherwise work product, didn't come in up to that point, but because it was used to refresh somebody's memory, then it does. And so, yeah, your report comes in. My position on another example, and I'll go back to, federal criminal cases are a really good example because people like federal criminal defense attorneys freak out about Rule 302 and what's known as reverse jinx all the time, and they're really touchy about not generating contemporaneous notes and statements from witnesses who they think might be defense attorneys. And there's a reason for that. It's because there's a pretty good chance that if you take a statement, like a verbatim statement from a witness who they call, that statement, you'll have to turn that statement over. And that's unhelpful to the defense because all the things in that statement, they're like that's a lot of information that might be used to potentially impeach your own witness. And so they're touchy about that for a good reason. And so how they get around that particular thing is you might not take notes when you're talking to a witness in those cases. You certainly wouldn't take a verbatim statement from a witness if you had any inkling that they were going to be somebody who your side is going to call. You might wait a day to write the report. Those are all things that investigators in those particular types of cases will do to avoid having the report come in. And I've also met attorneys who will say, don't write a report about that witness in those cases. And I know good attorneys who believe that. But my personal opinion on it is that just because there's a chance that something might be turned over to your side, that's not an excuse not to document it. I think it still needs to be documented. You just need to be careful about how you document it. And so what that might look like is write a report about it. Don't put things in quotes, or be careful about how you frame things. I tell a story. I've told the story a billion times and it's in the book, but like I had this case once where I took a statement from somebody and I didn't take a statement from them. I interviewed somebody. I took notes from it. It was a federal criminal or a DC criminal case. And the notes that I took, oh God, it's just such a long story. It's in the book, read it. But the specific writing of the notes ended up becoming something that they used to try to say that I didn't understand what the person said. And it was because I didn't put a period between two lines on a line of notes. And so without the period, it completely changed. It could be interpreted in two different ways. And so I've always, like, after that experience, I was like, everything matters. Punctuation matters because it completely changed it. And I had to get cross-examined by this prosecutor about this thing where I knew what the guy said because I remembered it, but he used it to try to discredit me, and it pissed me off. And I didn't like it. So I'm always really careful after that. So, my point is be careful with how you document it, but I don't tell my investigators to try to game the system. Like, we're not trying to game the system or avoiding documenting things. We're going to document stuff really well. And if it turns out that our report gets to the other side, it's going to be accurate and it's going to reflect what was actually said. I'm not going to give them anything, but but it is what it is. And so I don't know, that's my position on that. But beyond that, yes, label the reports, be careful with how don't send them to other people, don't copy other people on them. Sometimes you have a client who's like, their family wants to be involved in the case. Well, if it goes anywhere else other than on the team, then it's, you can't control where it goes. And so it's fair game for other people.
Yeah, it's good stuff. Thank you. I don't see any more questions coming through yet. Just a reminder to the people listening, if you have a question, put it in the chat and we'll make sure it gets covered if possible.
All right, thanks. Yeah, so next thing, again, kind of jumping around. I realize we're not going to go super deep into stuff, and I'm sorry about that. But yeah, I mean, it's as you know from reading it, there's a lot of information in there, and so it's kind of hard to cover everything. But I wanted to give some people a little bit of kind of a flavor for some of the bigger issues. So next, well, they're going to talk about a duty to preserve. So yeah, you have a duty to preserve evidence in your cases, and that if you don't then there can be pretty big consequences for the case that you're working on. Most of the evidence, I mean, where this comes up now a lot is in digital evidence. I mean, you take video or audio recording of something, and you're required to keep that, even if it's not helpful for your case. And usually the way that it's called spoliation. Usually the way the judges handle that is by dismissing the case or issuing what's called an adverse inference, where the jury can interpret the missing evidence basically in the worst possible light. And one of the cases that one of the because the case law on this, one of the major cases on it was actually involved a private investigator who was investigating a lawnmower accident. And in this case, I don't know actually what the specific injury was, but somebody was injured on a riding lawnmower, and the plaintiff's investigator did like an investigation of the lawnmower by examining it, and at issue was whether the governor on the lawnmower was like activated or not. The governor is like supposed to prevent the blades from turning unless somebody's like sitting on the lawnmower. So somebody's sitting on the lawnmower, the blades are moving. If they're not, it's not. And this investigator fiddled with the lawnmower, probably with the best of intentions, but didn't document it. Didn't document what they did. So no video of it. No, as far as I know, no report about it. Just basically reported the information to the attorney who they were working for, I think verbally, and then died. So the investigator died later from presumably something unrelated. And the issue became that there was no way to know whether the governor was on or off at the time, because the defense investigators of the defense hadn't been given the opportunity to be present for the examination, and there was no documentation of it, and so the evidence was spoiled. And in that case, the charges were effectively, I mean, the plaintiff lost it at summary judgment. And so the lesson there is that when you go out and you do an investigation, regardless of what kind of investigation it is, whether it's fiddling with a governor on a lawnmower or collecting evidence for a personal injury case where you're collecting security footage from a gas station or something, you have a duty to preserve that stuff, and that means capturing it, documenting it, and making sure that you hold on to it, whether it's helpful or not. That applies to obviously any physical evidence, and applies to digital evidence, and applies to your reports and the stuff that you generate. I don't think there's too much really to talk more about that, but do you have any questions about it? Guess not.
I don't see anything coming through.
Cool. Okay. Um, so next we're going to talk about hearsay. Um, Basically everything that you like, everything that you do that you're going to have to potentially testify about, usually falls into kind of like two broad categories as I see it. One is the things that you physically observe. I mean, if you're doing surveillance or um, things where you're physically observing something, I mean, you're seeing that thing, and you're testifying about what your observations were. So if that's your first person experience, that's not hearsay. If you're talking to somebody, I mean, basically everything else, well, I mean, research related, you're involved in the research, but you're gathering the research from other sources, and so that's um, the substance of the things that you're gathering is all comes from another place. If you're interviewing folks, basically everything they say is hearsay by definition. So hearsay, an out of court statement that is offered for the truth of the matter asserted. So basically that's everything that we do. So I find it really helpful when it comes to writing reports or taking statements or basically documenting our cases, to understand what the exceptions are and why it is that what we gather can be admitted into evidence in some circumstances. Um, if you talk to somebody um, and they tell you something, um, you're not really like you're the case that you're working on, the attorney who you're working for needs that person ultimately to testify in the case. They're going to have to tell their story firsthand, most likely. Um, where um, where the value of your investigation comes in, like what the reason why we do interviews. I mean, it's really twofold. One is that the things that we inform the attorneys, we give them intelligence about what somebody's likely to say if they're going to testify, and so a lot of it's just gathering that general information about this is the thing that happened. But most of it really comes into getting details from folks that the attorney can then use to impeach them later because they're inconsistent. And so understanding, I guess, that's what, like, I've testified, I don't know, 100 times in my life, and most of the times that I've testified, it's because somebody has said something different than what they told me, and that thing can be anything. It doesn't even necessarily need to be substantive to the case per se. It just needs to be potentially different. And so when you interview somebody, understanding that that's the thing, that's the thing that we're doing, um, it helps inform how you take notes, how you document stuff in your running resume, when to take statements from people, when not to take statements, because you understand that anything could be a potentially inconsistent statement. So so that's basically I guess the main thing I really wanted to say about that everything's potentially hearsay, that you want to gather as much detail from people as possible to generate potentially inconsistent statements, and that there's some other exceptions which you should look out for when you're doing interviews. There's a whole bunch of hearsay exceptions. I go over some of them in the book. I put them mostly in categories um, that I think are useful for investigators kind of in the field. You don't need to be like a guru, you don't need to be a lawyer. I mean, lawyers don't even know all the hearsay exceptions. But I do think it's really helpful to understand what the broad categories are, because when you're talking to folks, um, sometimes the things that people tell you can seem pretty attenuated from what the source is. We have people who say like, well, I would tell you this, but it's just hearsay. I just heard this from somebody else. And I would never let that dissuade you from getting the information, because, well, like, you're supposed to investigate the thing to its source and find out what really happened. But moreover, a lot of times the things that people say can fall into different exceptions for various reasons. Prior inconsistent statements is certainly one of them. Recorded recollections, I kind of mentioned that one before, is like a way to refresh somebody's memory. So if you interview somebody and they forget later, your report can be used to refresh their memory. And so that's the way that the hearsay of what they told you could come in. And the theory behind that is basically that um, something's more likely to be accurate the closer it is in time to the thing that happened. So if you if something like an event happens that you're investigating, whatever the thing is that affects people, in the cases that you're working on, you go out and you do interviews of that thing, hopefully as soon as possible after the thing happened, um, because you want it to be close in time with the event. And they tell you what happened, and then the case goes to trial 2 years later. Um, you're what they told you at that time is closer to the event than the trial. So there's a really good chance that they would come in. Some other broad categories of things, I mean, kind of along the same lines, but things that that are more likely to come in or that fall under hearsay exceptions. One of them is excited utterances, is my favorite, because if you're investigating something, like I said, it's traumatic for everybody who's involved in it, and if it's a crime, people blurt stuff out, when it happens, and those like blurted out, like excited utterances in the heat of the moment, the heat of passion. Oftentimes, those can be hearsay exceptions. And so, when you're interviewing somebody about something happened, you'll hear you hear things like people say he was upset or he was very angry, or well, things like that. Descriptions of like telling what their impression of what the person appeared like at the time. And as an investigator, you want to try to dig into those impressions because they're usually based on some fact. So, for example, why was he like? What were his mannerisms that made you think he was angry at the time? Well, his voice was raised. Okay, well, that aspect of his voice being raised could potentially make a statement that witness attributes to that person, the second person who you're talking about. That could be the difference between that statement coming in or not, because if his voice was raised, if he was raising his arms or whatever the thing he was doing, that's more likely to be ruled as an excited utterance. It's more likely to come in. Likewise, if you put the quoting, you put it in quotes, and so understanding what that thing is, understanding what the exception is, it shapes how you potentially write the report or how you write it into a statement, thereby increasing the chances that hearsay exception is going to come in later on, and that it's going to help your case. There are other exceptions kind of similar to that, like present sense. What's under the present sense exception? Think about like if somebody calls 911 and they're describing something that they're witnessing across the street, and they say like, oh well, this guy just broke into this building. What does he look like? Well, he's a white guy, he's a bald head, he's got a mustache. Okay, well, those impressions that person's giving over the phone, that's a hearsay exception because they're giving them in the real time as the event's happening. And so that's another one that's kind of similar to that. But excited utterance is great because, again, everything you're investigating is traumatic for the people that are involved in, and if you can get to the grit of what happened and the emotions of what happened, and you could describe those emotions using the language that the person uses and put the things in quotes, you might get a great exception. Like Greg said I shot him. That's like whatever the thing is. So it's good to know what those are. And then another one too is good to know is a statement against a confession. Basically, confessions are, a statement against self-interest usually is admissible. And obviously, I mean, depending on what kind of work, I do a lot of insurance fraud work nowadays, where I do interrogations of folks in suspected stage accidents, and so when I'm documenting what people tell me in those cases, you want to put it in quotes and recognize it as a statement against it. It's confession when you hear it. Obviously, it's better if you get it on audio recording and somebody signs something, but to the extent that they won't do that for whatever reason, you want to make sure that you document it and recognize it for what it is, because it might come in handy later. And then lastly, sort of there's a hearsay exception that's kind of like, it's a whole bunch of hearsay exceptions that really apply to documents of all different types. I mean, there's a whole bunch of different exceptions to documents. I would say generally that to like if you're gathering documents for a case, I mean, there's a reason why you want to get them certified. There are some ways to authenticate records to increase the chances that they're going to be admitted. But broadly speaking, if you're gathering records from third party companies or even people, there's a pretty good chance that those are going to be admissible under one of the many document exceptions for hearsay. But it helps to have kind of an understanding of those things because again, it informs how you ask questions and how you write your reports and take statements and stuff. But yeah, have any questions about that stuff?
Yeah, that's all great. Wow. Um, there is a question from Jeff Anspaugh. Apologize if I'm pronouncing it wrong, Jeff. It's not. It's about artificial intelligence and whether that's changing things. He says, "Are you seeing new challenges related to preserving evidence, such as emails and photos, in a world where AI is being misused? Are there new steps being taken to ensure the validity of electronic evidence, such as hiring experts to verify the emails and photos are legit?"
Yeah, I mean, this is obviously the future. I don't have a lot of experience with AI personally. I've never hired an expert in that. I've never had it come up in my case, any of my cases where somebody, I mean, to my knowledge, I think this is true, that I haven't had a case where, an AI altered photograph has been an important element of the case. But I certainly think I certainly think you're going to see that. Yeah, I don't know. I mean, to me, this is a question that the courts are going to have to deal with. And I'm not an expert in it, so I don't want to really speculate about that. But I mean, I will say that, like, from a practical stand, and I talk about this in the book too, that, I mean, if you're in my investigations personally, there's not a lot of instances where I'm like imaging people's phones, for example, or computers, or I might subpoena Instagram or something, occasionally. And when I do, I find that it's like pulling teeth to get anything from them. But like, we do that, right? And so we're getting information from the source, from the source. And we certainly subpoena people all the time for different things, and we get the records that they provide for us. When we do research on people, I mean, this is like the real world. Usually we're limited to what we see online, or what we see in court databases, or if we go pick up a file, we're limited to the things that we observe. And so I recognize that that there's a lot of opportunity for there to be misinformation in those sources. I mean, if you're looking at somebody's Instagram account and there's a photograph there that is of people in your case, and and somebody altered that photograph, I mean, I think that there's a lot of potential for that information to be misused or to be wrong. But at this time, to my knowledge, there's not really anything. There's nothing to suggest to me that you should gather that information any differently than you would if it was any kind of photograph, because your job is not to determine the truth of what the thing is. Usually, I mean, your job is to collect it and to document it, and then usually, there's we work in the court system. I mean, somebody is going to decide whether that evidence is admissible or not admissible. I mean, I would say that yeah, there are experts. I've seen experts on the news, for example, talk about deep fakes, and certainly those people exist, and I'm sure there'll be like a billion of them in a year. But I think that from my standpoint, I mean, I work in talking to people and gathering information that's in front of me or that's available to me, and so I'm likely just to keep doing it the way I always do it, which is to, I mean, if you're not subpoenaing it from the source, you're either using a software program to take it off the internet, or you're just doing screenshots of it and documenting it in the same way that you would document anything else. But yeah, no, I recognize that's the future. It'll be interesting to see where that goes.
Yeah, sure will. Thank you for answering that question. There's one more. If a person sends an encrypted email to convey information to the recipient, and then that person deletes his or her encrypted message so it no longer is visible to the recipient, how does the recipient defend his or herself, him or herself, regarding the existence and content of that encrypted message? Got anything on encryption?
Yeah, I'm not an expert in encryption either. I'm just not. Yeah, I mean, so and let me actually ask a question from that. So if you're, and this is my ignorance. So if somebody deletes the encrypted message on their side, I mean, is it no longer available for the person who sent it? I mean, they no longer have the message. Is that the implication?
Yeah, so these are coming through as direct messages. I think this is Pat. It's no longer available
Yeah.
at that point.
I mean, like, yeah, I mean, so, right. So what do you're talking about, um, cracking the code to unencrypt the other message. I mean, I just like, good luck. I mean, yeah, I don't think it's very likely that that's going to work. There are, I don't know, there are digital forensics people who work in that space. I mean, when I need somebody like that, I hire them and I do what they tell me to do, so that's my take on it. You can't be an expert in everything. Yeah, sorry, that's not very helpful.
No, thank you.
Yeah. Okay. Well, last thing I was going to talk about is document retention, and then I'm going to open it up for any final questions, and we'll end. So yeah, the last of the 5 principles of investigative documentation is document retention. So investigators, I mean, unless it's by statute in like particular states, I don't know like the laws of every state, but at least in the states where I operate, which is Maryland, DC, Virginia, West Virginia, there's no requirement for investigators to keep documents for any length of period or any length of time. However, there are requirements for the attorneys who you work for, and that depends on the type of case and the jurisdiction and other things. Our policy has been, and our policy has evolved, but looking at the statutes, like the broadly speaking, the different types of cases and stuff, we've determined that generally speaking, 5 years is pretty good for most types of cases, most civil cases, most criminal cases, well, at least the misdemeanors and cases that pled. Usually, we keep records for 5 years, and I think that's a pretty good like across the board rule of thumb for most cases. There's a big asterisk. So what we do, and I guess I'll just go ahead and say the asterisk. The asterisk is for serious felonies that went to trial where there's any chance of appeal, you should be keeping those records indefinitely. I mean, I've had cases that have come back 20 years, 20 years later. In fact, the book opens with a case in which I testified about a murder case that I worked in the early 2000s, and records that I didn't have, and how that all played out, including like transcripts of my testimony and stuff. And that's like, so I mean that it happens, and for that reason, you should be keeping those records indefinitely. But 5 years is pretty good for just about everything else. What we do is we have a color coded file system where, well, for the physical files, and we just we age things for 5 years, and then after 5 years, we will email the attorney. We'll ask them if they want their records. Usually they'll say no, and then we destroy them, and we create a document that says when we destroy them. If they say they want the records, we send them everything. And that's pretty much how we do it. It's a little bit more complicated than that because there's different types of records. Your emails are records as part of your case. Those are the same, they fall into the same category as the reports and other things you generate. For that reason, emails, notes are another thing. I mean, I still take like handwritten notes. Other people take digital notes. It doesn't really matter. It's all the same. But for the reason of to make document retention more seamless, it's really important. And this is like something that I find that investigators outside of my company don't really do. So this is like, you take only one thing out of this whole hour that I've been talking. This is the thing to take out of it. It's really important that you label the emails that you send and the documents that you save with the case name or something that delineates that thing from something else. If you have a practice that like involves any number of investigations, I mean, we have like 150 cases going on at any one time, so thousands of cases over the course of our career. You'll quickly find that it's just completely unmanageable. There's just no way that you can keep that stuff unless you have a system in place from the outset when you start a case. And I get cases from attorneys, from other investigators all the time that are labeled like new case or, interview or, these like really generic terms that don't relate to the thing that, to the actual case. And so again, if you take only one thing out of this whole thing, it's to label your emails with the case name, and to have a system for doing that so that they all fall in place at the end, and you can keep track of them. And same with files. I mean, you should be keeping files with by naming the files that you keep with the case name and with the things with what it represents. And that's pretty much all I think I want to talk about there, unless people have questions.
Nope, I don't see anything. I think it's funny though, because I've actually got a case sitting in my inbox right now that's titled new case. So
yeah, it's amazing. It happens all the time. I mean, it's like, and it's so basic. It seems like so obvious, but I mean, it's because, I think, when you're working on something, it's the only thing that matters. It's like you're working on this case and it seems like the only case. It's like it seems like the most important thing, and you don't think about the long game. And the long game is that, again, to go back to what I said in the very beginning, that the lives of the people who we are doing investigations for, they matter. And they matter long after you're working on their case. It's like you work on the case and then their lives continue going, and then they might have appeals and other things that go on. And someday they might ask you for those records. And so it's part of caring. It's part of like rolling the burrito right and not, sending your rental car customer an outrageous bill. It's part of caring about your clients. It's an exercise of doing a good job on their cases and stuff. So, but simple. It's a really simple thing you can do that makes a huge difference. Okay, so yeah, without any other questions, I mean, if you have, I hope you'll buy the book. It's on Amazon and a lot of other places. And there's the names of the 2 books that I've written in my company. If you ever need anything in the DC, Baltimore area, I'm happy to help folks who need things or want advice or whatever. So it's been a pleasure to talk to you guys.
well, thank you so much. Yeah, it's been a really, really good, mostly, I feel like it kind of raised as many questions as you answered, but that's a good type of information to be receiving. So really appreciate
I have to give people reasons to buy the
us.
book. I can't go through everything.
That's true.
Yeah.
That's true.